Friday,
Okay.
a little bit after 11. I'm John Lee with St. Louis Real Estate Investors Association. We are here with Miss Kathy Davis for our weekly update from Davis Travellini LLC. So how you doing, Kathy? You're smiling today. Always good to see.
I am feeling pretty good. I don't know why. I was just texting with some friends of mine a little while ago, and I said, "Remember parties? Remember when we used to have parties?" So I'm hoping that we'll get back to that quickly. My husband is getting his second Pfizer vaccine today. He's a veteran and he's getting it through the VA, and they are actually running it as a fairly efficient and reasonable system. So I'm pretty happy about that. I'm always happy when our veterans get treated well. So if anybody is a veteran, you might want to try to get in with the VA for your vaccination. They're doing the Pfizer shot here locally, and they have a clinic down on Washington at the west end of the city that is doing it. And like I said, when he went for his first shot, it ran very smoothly. So what do I have this week? I've had a number of clients asking me about the MHDC ERAP money, and I know one client that is a very large client that has thousands of units all over the country, and they have somebody in-house who's been doing this stuff, a leasing person, and I think that she has been successful in a few cases in getting the money, but the way she described the process, it sounds very painful, and it's taking a long time and that kind of thing. That's the one program right now that landlords can apply for, but they still have to have things from the tenant, and they're very bureaucratic and picky over minute details. This client was telling me about an application that the tenant didn't put their middle name on one of the papers, so they sent it all back. So they corrected that and sent it in again, and they didn't like something else, and it was a different person reviewing it, so they deleted the whole thing. So it's the usual pain in the butt. And I think I told you last Friday that I was on a call last week with some people from Sam Page's administration in the county about the $30 million that they got and how they're going to do it. And I strongly advocated for landlords being able to apply, and for us to be able to use a judgment and a rent possession as the prima facie evidence of the landlord-tenant relationship, and that the rent was owed and the address and that kind of thing. We file those lawsuits by affidavits. The stuff is reviewed by a judge before the judgment's entered, even if it's a default. And I think, most of the landlord attorneys would not file that stuff if we didn't know the client and believe the client and have reviewed the documents and, have it be correct. And I think I made the crack last week that it was easier for me to get hundreds of thousands of dollars in PPP money than it is for a landlord to get $2,000 in rent for a tenant. And I think that's unfair. So I don't know what they're going to do, but I was checking on their website yesterday to see what progress they had made. And they are saying that this new program with this 30 million for St. Louis County, they are not even going to start taking applications until March. Now, I don't know what they are doing all day that takes them that long to set this up. And this isn't the first time. They had programs last year, so I really strongly object to that. I feel I'm pretty ticked off at them, and I'm going to try to figure out if it will do us more harm than good if I call and complain to somebody. I don't think we're going to be able to move them any faster. In the city, we're getting some good news. We think we've been asked some things by the judges and people down there about how many executions we have pending and that kind of thing. And we think that there is a strong chance that they will open up to all kinds of executions at the beginning of March. Right now, you'll remember that the city is the one that is sort of following the CDC guidelines, where they have stayed rent evictions, but not the other kinds of evictions. So if they allow us to do the rent evictions in the city, we will still not be able to do the ones where the person has a CDC declaration. However, we might be able to challenge those. We're not sure yet. We didn't do well with challenging them last year, but the judges might be getting more fed up with the BS at this point. We're not sure. But most of the tenants that we sue do not provide the CDC declarations. So we should be able to, we're hoping to be able to start executing on a lot more stuff in the city. There is a backlog. Nobody seems to know how big the backlog is. It's hard for us to even tell. We know that we have a bunch of stuff where we have judgments and we have executions pending. We probably have somewhere we have the lawsuits, but the client hasn't told us to execute yet because they know that we can't. And I'm sure we have some clients who are holding off on even filing until they know that they can get, a result. So what they'll do is they'll go in order that the executions were filed. I'm not sure if my office has any in the city that are from before the pandemic. We do in the county because the county has had a total stop, for almost a year. But hopefully they'll start with those first and they'll march through them. I think the other thing that will happen is, we like you to do the sheriff's executions on the judgments if possible, because that gives you the statutory protection about not being liable for the tenant's personal property that they leave behind. There's a statute that says if you do a sheriff's eviction, you're protected from disposing of the person's stuff. So that protects you somewhat. I'm sure that we have some units out there where there's stuff there and maybe there's some activity or we don't know what, and the landlord is not sure that the person is gone. And we're waiting for the sheriff's execution to be sure. I also think that there are tenants who play the system and they know that when they get the posting from the sheriff, which is usually about a week in advance of when the sheriff puts the person out, that they will move then. So we anticipate that there will be a lot of movement and that backlog of executions might get processed more quickly than we think. I think the presiding judge and the sheriffs are thinking it's going to take months, and I actually think it will go faster than that. So there is some hope in the city. St. Charles and Jefferson, as far as I know, are business as usual. We're doing the stuff that we're doing there, and that's all fine. And I think that's the same. The same is true of the other counties that we don't go to that often, but I think that's all true there. Let me look at the chat. I saw a couple of questions, but I want to make sure. ERAP started accepting applications January 4th. That might be the ERAP through the state, through MHDC or through the state of Missouri. There's going to be a new county program. You can look on their website, which is half of it's not updated, but it's talking about the new program. They got $30 million from the feds within the last few weeks, and they're going to start taking applications for that in March, according to their website. So they don't have the process set up yet. Can you get a continuance on a trial docket? It depends on the judge, how old the case is, what city it's in. If you can give me more info, I might be able to help with that. Someone has posted Missouri Housing ERAP Emergency Rentals Arrears Program. I thought it was assistance, but it's probably arrears. I don't know. That program, that Missouri Housing ERAP, a lot of our landlords have found that very difficult because of the restrictions and requirements that are on it. But it is one that allows the landlord to apply. How does the trial docket work? Yeah, I need more info on that. When we do these dockets, on Zoom or WebEx, if we can't come to an agreement with the tenant, we ask the judge for a trial date. And the trials right now are all being conducted remotely. We think that we'll be doing some in-person work in some of our counties in St. Louis City and county soon, but we don't really know. But right now we're doing our trials. Usually within a couple of weeks after the court date, we'll have the trial date. We'll get the court date that day. Because of the way they're doing it now, we sometimes are getting trial dates that are further out than we used to get. When we were doing it in person, we'd get a trial date the following week, maybe 2 weeks later. Now the judges are just slotting one trial at a time, like giving them half an hour slots. So sometimes we have to wait for our turn. Our new judge in the county, Judge Medler, has been wonderful about not confining us just to Thursday settings, giving us any day of the week that he has it, and that kind of thing. So, we are working through these. And sometimes, again, we settle those before we have to actually do the trial date. In the old days when we were in person, Christine and I in the county would get to the court, we'd get there very early. We'd talk to the people who came in early. We'd hopefully get their cases settled and get them out of there. The judge would call the docket. I'd be out in the hall settling as many cases as I could. And, sending the ones in that had to get trial settings. And then when we got to the trials, half the time someone asks for a trial because they know it buys them a couple of weeks. Then they don't even show up for that. Or they do show up. And at that point, they're kind of realizing that, yeah, they didn't pay the rent and they better work something out. So we get a lot of those settled. And so we could set, 20 trials at 10 a.m. and end up only trying 2 of them. Everything else would get resolved. But it just doesn't work the same way to have people sitting on a Zoom all morning, waiting for their turn. It's just harder. And another thing that I think is kind of, it's making us very unhappy. The city's using WebEx, and that's a lot harder to deal with. It's a lot less user-friendly, and for the pro se defendants, they have trouble with it. The breakout rooms aren't working as well. There's some people who are just on their phones with no camera, and they can't go to the breakout room. So we've much preferred using Zoom in the county. Well, the statewide court system has decided that everybody's going to WebEx April 1st. We're not happy about that. We've whined and complained about it and gotten nowhere. Somebody must have stock in WebEx. I don't know. But we're very concerned about how that's going to affect our remote hearings. The good news from the county is that they went to phase 1 this week. And you may recall that I've told you that we have to go to phase 2 and then they'll let the sheriff go out again. And I also happen to know, because of a colleague of mine that has a case, a 441 case there that's very bad, that the judge says that the county sheriffs are going to start getting vaccinated next week. And so the county sheriffs apparently are fragile flowers who are not able to go out and do executions and live in the world like the rest of us have to do. And that's why we haven't been able to get executions, because we're too worried about their health. So once they start getting vaccinated, maybe that will move the county off this no execution policy. We have a bet with a bailiff that he thinks we'll be at phase 2 before March 15th. Christine thinks it'll be after that. So if we go to phase 2 before March 15th, Christine has to buy me and this bailiff lunch. If we don't go into phase 2 until after March 15th, the bailiff has to buy me and Christine lunch. Either way, I get lunch. That's why you love me, right? Because I'm the smart one. I'm already perusing restaurant menus. Okay, let me catch up with the chat again. EREP, a St. Louis County Courts MSD case. Yeah, it depends, Steve. It depends on how old the case is and that kind of thing. You might want to try to call the attorney who handles it ahead of time and see if they'll agree to a continuance. But usually they continue those MSD cases all over the place. I will say that one of the big MSD cases is in my division on Thursday, and they had a lot of old cases, and the judge is cracking down on them. So if your case is more than 6 months old, it might be harder to get a continuance. But those cases are usually pretty easy to work out, so you might want to try to work it out with them. Is there a St. Louis County ERAP and a Missouri Housing ERAP? Well, there's a Missouri Housing ERAP that is the program that allows landlords to apply, and I find it very difficult. Landlords are finding it difficult to work that system. There is new money coming to the county. They may already have it, 30 million. And again, they say they're going to start taking applications for that in March. We haven't seen any of the details of that yet. I'm hoping they'll allow landlords to apply, and I'm hoping it will be, less bureaucratic and less annoying than previous programs and will work more swiftly, but we'll have to see. Now, I wanted to talk to you guys a little bit about some lease clauses, and I talked with John ahead of time, and I'm going to try to draft these up hopefully this week, and then he's going to post them on your website. And we've talked about lease clauses before, but here's my theme for today. The county has a local rule, and has added a local rule, and the Missouri Supreme Court may make this rule statewide, that we have to itemize out everything that's in a rent and possession judgment in the judgment. It used to be that even the court forms just had a space for the amount and a space for the address, and court costs. We have developed our own forms a couple of years ago that we use, and we do itemize out some things on those forms. We've already been doing that. A lot late charges get a lot of scrutiny from judges. A lot of them don't like late charges. They'll waive them, that kind of thing. We're suggesting that you might want to consider, instead of having late charges, have discounted rent, where the rent is $500 if paid on or before the first of the month, and $550 after the first of the month. If you had it written up like that, we wouldn't have to write it up as a late charge for the judge to look at it and strike it. We also like clauses, if you have a lot of charges in your lease, which I really prefer that you have it all as rent, just figure out what your costs are going to be, your MSD, whatever, and make the rent $750 a month or whatever you need to do to cover that. But if you have additional charges, I've seen all kinds of charges, washer and dryer charges, month-to-month fees, pet fees, all that kind of stuff. Refer to them in the lease as additional rent, that those charges are additional rent, not separate charges. Again, there we'll be able to put them in the judgment as rent rather than itemizing them out as all these different costs that might draw more scrutiny from a judge. And then the next thing is, there are a couple of judges in St. Louis County, and I can't say their names, but they are just tenant lovers. I think if they love the tenants so much, the tenants should all go live with them because they're not paying to live anywhere else. But they are trying to bring back the idea that they think tenants can get jury trials in rent and possessions. We have given a legal memo to our judge. We think it's very clear that you can't get it on the first impression now, only on the trial de novo, and then they can only stay in the property if they post a bond. But we really like to see jury waiver trials clauses in your leases. In addition, unlawful detainers are allowed a jury trial by statute. And I have at least 2 cases now that are hung up for I don't know how long because they've requested a jury. They're unlawful detainers. So we're getting them out, not for non-payment, but for other reasons. And we're hung up until we can get a civil jury. I was talking to one of the judges the other day who told me that they have so many confined people that have criminal jury trials that get a priority because they're being held in jail until their trial, that he thinks we won't see civil jury trials until next year. So for 2 reasons. One, because some of the judges are crazy. And secondly, because right now it's getting to be really hard to get a jury trial for a long time. We really want to see those jury waiver clauses in your lease. Okay, let me peek at the chat again. If we apply for the state ERAP now, will that prohibit us from applying for the county ERAP if we're still, I think that's a really good question. Can you apply for more than one program? We would like to look at what you're going to sign to answer those questions, whatever their agreement is. I had somebody call me yesterday to ask me if they got turned down from the state program, did they still have to wait the 120 days? And I said, I'd like to see what you've signed, if anything, but they can't just make you not do it if they didn't turn you down. There's no consideration then. You don't have a contract with them. So Mo ERAP will pay up to 6 months back rent. What is the amount for the county? We don't know yet. They're still developing their program. So we don't know. I did encourage them when I was in the call last week, Deanna Venker and Cora Faith Walker. I did encourage them. I said, we have people who haven't paid in over a year. We can't have any, $1,000 or $2,000 limit here. There has to be the ability to get more money than that, or we're not going to be able to do it. I will be filing for city eviction on Section 810 and on March 1st. Lease expires. Tenant is withholding rent. We just bought the property last month. Cash to leave. Cash for keys is always a good strategy in some situations, and maybe now more than ever. If you're going to be filing on a Section 8 tenant whose lease expires at the end of February, the chances are that she's going to get a legal aid, EHOC, or Art City lawyer or pro bono lawyer, And they're going to know you're doing an unlawful detainer because it's a lease expiration. They're going to know that they can ask for a jury trial, and that will hang you up for a long time. So yeah, I would bargain however you can, and make sure, since it's a Section 8 tenant, that you look over that lease carefully, because some of those automatically renew. So that's my thoughts on that. Anybody else have anything? How are y'all doing? Hanging in there?
I had a question, Kathy.
Uh,
On the, I was reading on the internet where people are putting the late fees, or not late fees, their late payment or their payment histories on the credit reports. How are you able to do that? Is that a complicated process for us, or is that something that we need to have paperwork on our lease that your office could do that for us? Because I know in many instances, when I was with Xerox and American Express, normal companies pull credit reports, and if they see that they're not paying their rent and they know that they're employed, that's going to disqualify them for any type of promotion opportunity. In many cases, that may even get them dismissed from their job if there's a security clearance involved with it. And I know that's the case there. So is there a
Well-
way that we can do that on our end if they're not paying the rent?
You have to be a member of the credit bureau. We're a member of TransUnion, but we are only a member for skip tracing and pulling people's credit reports for that reason. When you file a lawsuit in the courts in Missouri, there's a form that you fill out online, and you can put the tenant's social security number in that form. If you do that, when you get a judgment, the credit reporting agencies review those judgments. They have a new rule as of the last year or so, where they will only show those judgments on a credit report if the social was reported when the case was initially filed. But if you do that, the judgment will show up on the credit report. You have to be a member of the credit reporting agency to report as a creditor. And I'm not sure that's feasible for small companies to do. I think it's only feasible for the big companies. However, most places, most screeners will do things like check for judgments, and certainly someone getting a security clearance, they'll be checked for judgments. So if you have a judgment, even if you didn't put the social in, if they run CaseNet, they should be able to see that. There is, I think I've talked about this before, but there is a movement afoot among the tenant representatives to get all the tenants' judgments and bad credit from not paying their rent for the last year wiped off. So we're urging everyone to be extra careful when you're using CaseNet to check to see if they've got prior judgments, and make sure that you or your screeners call prior landlords and, go right to the source to get the information about whether they have prior judgments or not. Right now, the tenant can ask for the security level to be raised so their judgment can't be seen. Sometimes that's granted, sometimes it's not. We're anticipating a lot more of that. We're anticipating that a lot of these tenants have gotten enhanced unemployment, gotten assistance all over the place, had jobs, haven't paid rent, are going to walk away when this party comes to an end, and then they're going to ask for this evidence of their lack of responsibility to be shielded from the public eye. So we're going to have to be more on our game. We're going to have to be more on top of what we need to do to find out the ones who are bad. And there also might be some people who genuinely had a hard time and really tried to pay and that kind of thing. And that's information that you can get from calling the prior landlord. The other thing I would urge you to do, if you're checking CaseNet and you see a prior judgment, look for a satisfaction of judgment. That shows that the landlord or the plaintiff has filed saying it's been paid. And we would like people to give credit for that, because that will encourage tenants to pay their old judgments. And we always like it when we can get that back money or put people on a payment plan. That's always good for all of us. So look for those satisfactions and reward the people who do that. Call the landlord, reward the people who were good and called and tried to make payment plans and that kind of thing. Don't reward the ones who were just irresponsible and took advantage of this bad situation.
Now, on the post and serve, does that work also with the social security number, or do they it just shows up on there? Is there a way for us to put that on there where the credit reports would pick that up off of that?
I think it's going to be hard for you to put stuff on the credit report personally, Harry, but if you put the social security number in when you file the lawsuit, it should show up as a judgment against them.
Okay.
And someone's asking me how much to pay for cash for keys. Yeah, you know, I hear a lot of different amounts. I'm going to throw out like $500, $1,000. How much is the rent? You know, what's the tenant situation? I would make sure that you didn't give them the money until they're like gone. But yeah, for some people that might get them the security deposit on the new place. You know, I don't know. I hate to just throw out a number and you know, that's not really my area. I don't know how much you should charge for rent either. You guys are the experts there. Yeah.
Kathy, I've got a quick question from
Sure.
an email from one of our members, Kathy Shelley, this week, and I asked her if she could get on the call, but I didn't see her. She has a case where she's looking for some assistance for an HOA. Apparently, the contractor for the subdivision has turned over the HOA, turned over the HOA to the homeowners, and she's found out that there are a lot of outstanding debts to contractors still to be paid.
Oh, yeah.
Is that something that you could help with, or is there any attorneys that you know that specialize in dealing with those situations?
Are these in the nature of mechanics liens?
I get a feeling, yeah, these are
Yeah.
contractors that have
Listen,
actually
I'd
worked
be
on.
happy to talk to her. I might send her to a guy I know who really does a lot with mechanics liens, but I'd be happy to talk to her and figure out which direction to point her.
Okay,
Yeah.
Okay.
okay.
I have a question if everybody else is finished. This is on a little different venue, but tell me about how subleasing and lease assignments work in residential or commercial. Isn't the original person on the lease always responsible until the end of that lease or that agreement?
Unless there's an agreement that lets them off the hook.
Okay, but most leases are written that, they have the right to sublease or sign or whatever. And this lease clearly states that the original tenant is not released from responsibility of agreement, covenants, and all that legal jargon.
Hey, if it states it in the contract, then they don't get off the hook. And I
Well-
would say, Diane, that I think that kind of subleasing clause is more common in a commercial situation than in residential.
Right, absolutely. Well, they don't care. They want out. Well, not only that, they sold the business to somebody, and of course, because of the corporate entity that's the parent company, everything's confidential, which is kind of ridiculous because it's not exactly who you would think. But whatever the case is, it's confidential. But I'm willing to bet that it's more of a practice buyout. Includes the fact that they have use of that space with all the leasehold improvements and equipment, and the right to thereof and so forth and so on. And so for them not to be able to, give possession, they think they can, they think that if they had terminated at a proper time, which they didn't, that they would just be off the hook. Well, you can't terminate a lease and also assign it, can you? Or sublease it. The two just don't work.
Right.
You do one or the other.
It's either a lease or it isn't. It can't be both.
Right. So, they want their cake and eat it too. And these are very educated, rational people. And we got along just fine until this buyout issue came through. And, it's been difficult. Do you handle that sort of thing?
Yeah, give me a call.
Okay. Thank you so much. I really appreciate your help. Thank you.
You're very welcome. And everybody look in the chat. There's some information in the chat about the monthly fee for reporting to the credit bureau and some thoughts about, what you should offer for cash for keys. Okay, guys. Anything else?
One last thing, if
Yeah.
one agrees to an assignment and a release of the tenant, is there a typical percentage that the tenant would pay to get off the lease? Usually I've heard about assignment fees. Is there a certain percentage of the remaining rent?
Yeah, again, that's more of a business decision and a legal decision. And that's something that, you should negotiate.
Okay,
Yeah,
but those aren't untypical, I suspect, right?
right. More in
Okay.
commercial, like I said, than residential.
Right.
But yeah.
Right, because they're longer term. Thank you so
Right,
much,
right.
Kathy. I really appreciate
Okay.
it. Thank you.
Thanks, guys. We'll talk to you next week.
Thank you, Kathy. Appreciate it. very
Thank you,
much.
Kathy. Really appreciate your effort, John.